My name is Jennifer Bukowsky. I'm a criminal defense attorney in Columbia, Missouri. I'm in private practice. And as I'm sure you know, criminal defense is not about criminals. It's about defending individuals from the government. And not everyone charged with a crime is a criminal. The government makes mistakes. I represent a lot of Mizzou students in Columbia, sometimes even professors. The majority of people I represent have never been accused of a crime before. This bill treats misdemeanors as unimportant when that couldn't be further from the truth. As Joel was saying, a misdemeanor can have enormous impact on your life. Not just to your liberty, but lifelong impact to a person's reputation, their lifelong earning capabilities, their abilities to provide for their families, to be teachers, lawyers, nurses, police officers. It can cause you to lose custody of your children to your ex or the state in some cases, and it affects your gun rights, your ability to get federal student loans, and it can lead to you having years of needing government approval in every aspect of your life. So misdemeanors are a big deal. And I'm very concerned about the deposition provision in 545-400 here, which requires that depositions in misdemeanor cases may only be taken upon a motion granted by the court for good cause shown. If I'm spending the time, my client is spending the time and the money on a deposition, there's a really good cause for it. I don't think there's any good cause to protract the expense to the individual who's already taking on the enormous resources of the government to challenge a charge, to have to litigate in advance the need for the deposition. That causes me grave concerns. Also, it tweaks the language about whether prosecutors can do depositions. In the handout I provided, you can see in Rule 2515, prosecutors are already allowed to do depositions. The provision about preliminary hearings in 544-250 also causes me concerns, because generally when I'm doing a preliminary hearing, it's because my client is saying that I didn't do what I'm charged with. Maybe it was something less, maybe it's something different, but when we're going to plead things out, it's a big chip to just avoid. We don't have a preliminary hearing to antagonize the prosecutor and the judge. We plead the case out. We waive preliminary hearing. So I'm not sure. Hearsay is allowed, by the way, in preliminary hearings, as far as I've known in all the counties in central Missouri that I appear in regularly. I'm not sure why we need a statute allowing documentation without proper predicate. I think this is just opening the door for judges to make bad decisions. As Joel referenced before, me being with a client at a preliminary hearing can often result in the disposition of the case quicker, because my client might realize that he or she needs to plead, or the prosecutor or the judge might realize that someone made a mistake. The venue changes caused me concern in 545-490, because it eliminates the change of venue even for cause after 30 days. Well, what if something blows up on your case? There's all of a sudden a bunch of media, or if something happens and venue is no longer proper affairs in that particular county. It also eliminates change of venue for misdemeanors, and like I said, misdemeanors are important. The motion to suppress provision 542-296 causes me concerns, because I don't know why we can't have a motion to suppress an associate circuit court and once again protract and lengthen at the expense of litigating and challenging an unfair criminal charge.
Jennifer, are you about to wrap up?
Yes, sir. I know prosecutors are busy. I understand why they're wanting to have some provisions here to make things go along smoother, I guess. But what they're doing is really important to the folks involved and to the communities. And these are tools that I can use to get things right, to get the right results. I think this bill claims to fix things that are not broken, and that we don't need to fix them. We should not pass this bill.
Thank you very much.